David Gandee. Chapter 1. The nature, purpose, and function of criminal law. May the police officers be subjected to prosecution in both state and federal court. As the videotape begins, it shows that King rose from the ground and charged towards Officer Powell. Powell took a step and used his baton to strike King on the side of his head. King fell to the ground. From the 18th to the 30th second on the videotape, King attempted to rise, but Powell and Wind each struck him with their batons to prevent him from doing so. From the 35th to the 51st second, Powell administered repeated blows to King's lower extremities. One of the blows fractured King's leg. At the 55th second, Powell struck King on the chest and King rolled over and laid prone. At that point, the officer stepped back and observed King for about 10 seconds. At 1 minute and 5 seconds on the videotape, Brazino, in the district court's words, stomped on King's upper back and neck. King's body withered in response. At 1 minute and 7 seconds, Powell and Wind again began to strike King with a series of baton blows, and Wind kicked him in the upper thoracic and cervical areas 6 times until 1 minute and 26 seconds. At about 1 minute and 29 seconds, King put his hands behind his back and was handcuffed. Learning objectives. Define a crime, provide examples of criminal behavior, and distinguish between civil and criminal law. Number 2, explain the difference between criminal law and criminal procedure. Number 3, discuss the difference between felonies and misdemeanors and the differences between male NC and mala probita. 4, list and describe the various sources of criminal law. Introduction. Criminal law is the foundation of the criminal justice system. The law defines the conduct that may lead to an arrest by the police, trial before the courts, and incarceration in prison. When we think about criminal law, we typically focus on offenses such as rape, robbery, and murder. States, however, condemn a range of acts in their criminal codes, some of which may surprise you. In Alabama, it is a criminal offense to promote or engage in a wrestling match with a bear, or to train a bear to fight in such a match. A Florida law states that it is unlawful to possess an ignited tobacco product in an elevator. Rhode Island declares that an individual shall be imprisoned for 7 years who voluntarily engages in a duel with a dangerous weapon, or who challenges an individual to a duel. In Wyoming, you can be arrested for skiing while being impaired by alcohol, or for opening and failing to close a gate in a fence that crosses a private road or a river. You can find criminal laws on the books in various states, punishing activities such as playing dominoes on Sunday, feeding an alcoholic beverage to a moose, cursing in a miniature golf course, or making love in a car, or performing a wedding ceremony while either the bride or the groom is drunk. In Louisiana, you risk being sentenced to 10 years in prison for stealing an alligator, whether dead or alive, valued at $1,000. The nature of criminal law. Are these common characteristics of acts that are labeled as crimes? How do we define a crime? The easy answer is that a crime is whatever the law declares to be a criminal offense and punishes with a penalty. The difficulty with this approach is that not all criminal convictions result in a fine or imprisonment. Rather than punishing the defendant, the judge may merely warn him or her not to repeat the criminal act. Most commentators stress that the important feature of a crime is that it is an act that is officially condemned by the community and carries a sense of shame and humiliation. Professor Henry M. Hart, Jr. defines crime as conduct which, if shown to have taken place, will result in the formal and solemn procurement of the moral condemnation of the community. The central point of Professor Hart's definition is that crime is subject to a formal condemnation by a judge and the jury represented the people in a court of law. This distinguishes a crime from acts most people would find objectionable that typically are not subject to a state prosecution and official punishment. We might, for instance, criticize someone who cheats on his or her spouse, but we generally leave the solution to the individuals involved. Other matters are left to institutions to settle. Schools generally discipline students who cheat or disrupt class, but this rarely results in a criminal charge. Professional baseball, basketball, and football leagues have their own private procedures for disciplining players. Most states leave the decision whether to recycle trash to the individual and to look to peer pressure to enforce this obligation. Criminal and civil law. How does criminal law differ from civil law? Civil law is the branch of law that protects the individual rather than the public interest. A legal action for a civil wrong is brought by an individual rather than by the state prosecutor. You may sue a mechanic who breaches a contract to repair your car, or bring an action against a landlord who fails to adequately heat your apartment. The injury is primarily to you as an individual, and there is relatively little harm to society. A mechanic who intentionally misleads and harms a number of innocent consumers, however, may find himself or herself charged with criminal fraud. Civil and criminal actions are characterized by different legal procedures. For instance, convictions of crime requires a high standard of proof beyond a reasonable doubt, although responsibility for a civil wrong is established by a much lower standard of proof by a preponderance of the evidence, or roughly 51% certainty. The high standards of proof in criminal cases reflect the fact that the criminal conviction may result in the loss of liberty and significant damage to the individual's reputation and standing in the community. The famous 18th century English jurist William Blackstone summarized the distinction between civil and criminal law by observing that civil injuries are an infringement of the civil rights which belong to the individual. Public wrongs or crimes are a breach or violation of the public right and duties due the whole community. It is a social aggregate capacity. Blackstone illustrates this difference by pointing out that society has little interest in whether someone sues a neighbor or emerges victorious in a land dispute. On the other hand, society has a substantial investment in the arrest, prosecution, and conviction of individuals responsible for espionage, murder, and robbery. The difference between a civil criminal action is not always clear, particularly with regard to an action for a tort, which is an injury to a person or to his property. Consider the drunken driver who runs a red light and hits your car. The driver may be sued in tort for negligent damaging you and your property, as well as criminal prosecution for reckless driving. The purpose of the civil action is to compensate you with money for the damages to your car and for the physical and emotional injuries you have suffered. In contrast, the criminal action punishes the driver for endangering society. Civil liberties is based on preponderance of the evidence standard, while a criminal conviction carries a possible loss of liberty and is based on a higher standard of guilt beyond a reasonable doubt. You may recall that the former football star O.J. Simpson was acquitted of murdering Nicole Brown Simpson and Ron Goldman, but was later found guilty of wrongful death in a civil court in order to compensate the victim's family in the amount of $33.5 million. The distinction between criminal law and civil law proved immensely significant for the Kansas inmate Leroy Hendricks. Hendricks was about to be released after serving a 10-year prison sentence for molesting two 13-year-old boys. This was only the latest episode in Hendricks' almost 30-year history of indecent exposure and molestation of young children. Hendricks freely conceded that he was not confined. The only way to control his sexual urges was to die. Upon learning that Hendricks was about to be released, Kansas authorities invoked the Sexually Violent Predator Act of 1994, which authorized the institutional confinement of individuals who, due to a mental abnormality or a personality disorder, are likely to engage in predatory acts of sexual violence. Following a hearing, a jury found Hendricks to be a sexual predator. The U.S. Supreme Court ruled that Hendricks' continued commitment to a civil rather than criminal penalty, and that Hendricks was not being unconstitutionally punished twice for the same criminal act of molestation. The court explained that the purpose of the commitment procedure was to detain and to treat Hendricks in order to prevent him from harming others in the future rather than to punish him. Do you think that this decision of the Supreme Court makes sense? The purpose of criminal law. We have seen that criminal law primarily protects the interests of society and civil law protects the interests of the individual. The primary purpose or function of the criminal law is to help maintain social order and stability. The Texas Criminal Code proclaims that the purpose of criminal law is to establish a system of prohibitions, penalties, and correctional methods to deal with the conduct that unjustifiably and inexcusably causes or threatens harm to those individuals or public interest for which state protection is appropriate. The New York Criminal Code sets out the basic purpose of criminal law as follows. Harm, to prohibit conduct that unjustifiably or inexcusably causes or threatens substantial harm to an individual as well as to society. Warning, to warn people both of conduct that is subject to criminal punishment and to the severity of the punishment. Definition, to define the acts and intent that is required for each offense. Seriousness, to distinguish between serious and minor offenses and to assign the appropriate punishments. Punishment, to impose punishment that satisfies the demand for revenge, rehabilitation, and deterrence of future crimes. Victims, to ensure that the victims and victim family and the community interests are represented at trial and in imposing punishments. The next step is to understand the characteristics of a criminal act. The principles of criminal law. The study of substantive criminal law involves an analysis and definition of specific crimes, specific part, and of the general principle that applies to all crimes, general part, such as the defense of insanity. In our study, we first review our general part of criminal law and then look at specific offenses. Substantive criminal law is distinguished from criminal procedure. Criminal procedure involves a study of the legal standard governing the detection, investigation, and prosecution of crime, and includes areas such as interrogation, search and seizure, wiretapping, and trial process. Criminal procedures is concerned with how the law was enforced. Criminal law involves what law is enforced. Professor Jerome Hall and Wayne R. LaFave identified the basic principles that compose the general part of the criminal law. Think of the general part of the criminal law as the building blocks that are used to construct specific offenses such as rape, murder, and robbery. Criminal act, a crime that involves an act or failure to act. You cannot be punished for bad thoughts. A criminal act is called actus reus. Criminal intent. A criminal requires a criminal intent or mens rea. Criminal punishment is ordinarily directed at an individual who intentionally, knowingly, recklessly, or neglectfully harm other individuals or property. Occurrence. The criminal act and criminal intent must coexist or accompany one another. Causation. The defendant's act must cause the harm required for criminal guilt, death in the case of homicide, and the burning of a home or other structure in the case of arson. Responsibility. Individuals must receive reasonable notice of the act that are criminal so as to make the decision to obey that or to violate the law. In other words, the required criminal act and criminal intent must be clearly stated in the statute. This concept captured in the Latin phrase nullum crimen sine lege, nulla poen sine lege. No crime without law, no punishment without law. Defense says criminal guilt is not imposed on an individual who is able to demonstrate that his or her criminal act is justified, benefits society, or excused. The individual suffered from a disability that prevented him or her from forming a criminal intent. We now turn to a specific part of the criminal law to understand the various types of acts are punished as crimes. Criminal acts, felonies and misdemeanors. There are a number of approaches to categorizing crimes. The most significant distinction between felony and misdemeanor. A crime punishable by death or imprisonment for more than 1 year is a felony. Misdemeanor crimes are punished by less than a year in prison. Note that whether a conviction is for a felony or for a misdemeanor is determined by the punishment provided in the statute under which the individual is convicted rather than the actual punishment imposed. Many states subdivide felonies and misdemeanor into several classes or degrees to distinguish between the seriousness of the criminal act. Capital felonies are criminal subject either to the death penalty or to life in prison in states that do not have the death penalty. The term gross misdemeanor is used in some states to refer to crimes subject to between 6 and 12 months in prison, whereas other misdemeanors are termed petty misdemeanors. Several states designate a third category of crimes that are termed violations or infractions. These tend to be acts that cause only modest social harm and carry fines. These offenses are considered so minor that imprisonment is prohibited. This includes violations of traffic regulations. Florida classifies felonies as misdemeanors and non-criminal violations. Non-criminal violations are primarily punishable by a fine or forfeiture of property. The following list shows a category of felonies and misdemeanors and the maximum punishment generally allowable under Florida law. Capital felony, death or life imprisonment without parole. Life felony, life in prison, and a $15,000 fine. Felony in the first degree, 30 years in prison, and a $10,000 fine. Felony in the second degree, 15 years in prison, and a $10,000 fine. Felony in the third degree, 5 years in prison, $5,000 fine. Misdemeanor in the first degree, 1 year in prison, $1,000 fine. Misdemeanor in the second degree, 60 days in prison, $500 fine. The severity of the punishment imposed is based on the seriousness of the particular offense. Florida, for example, punishes a second-degree felony, the recruitment of an individual for prostitution, knowing that force, fraud, or coercion will be used to cause the person to engage in prostitution. This same act is punishable as a first-degree felony in the event that that person is recruited as under 14 years old or if death occurs. Mala in C and mala prohibita. Another approach is to classify the crime by moral turpitude, or evil. Mala in C, crimes are considered inherently evil and would be evil even if not prohibited by law. This includes murder, rape, robbery, burglary, larceny, and arson. Mala prohibited offenses are not inherently evil and are considered only wrong because they are prohibited by statutes. This includes offenses ranging from tax evasion to carrying a concealed weapon, leaving the scene of an accident, or being drunk and disorderly in public. Why should we be concerned with the classification scheme? A felony conviction can prevent you from being licensed to practice various professions, bar you from being admitted to the armed forces or joining the police, and prevent you from adopting a child or receiving various forms of federal assistance. In some states, a convicted felon is still prohibited from voting, even following release. The distinction between mala in C and mala prohibited is also important. For instance, the law provides that individuals convicted of a crime of moral turpitude may be deported from the United States. There are a number of other classification schemes. The law originally categorized as infamous those crimes that were considered to be deserving of shame or disgrace. Individuals convicted of infamous offenses such as treason, betrayal of the nation, or offenses involving dishonesty are historically prohibited from appearing as witnesses at trial. Subject matter. The textbook is organized in accordance with the subject matter of the crimes. The scheme that follows is lower than most states' criminal codes. There is a disagreement, however, concerning the classification of some crimes. Robbery, for instance, involves the theft of property as well as the threat of infliction of harm to the victim. And there is a debate whether that should be considered a crime against property or a crime against the person. Similar issues arise in regard to burglary. Subject matter offenses in descending order from seriousness are as follows: crimes against the state, treason, sedition, espionage, terrorism, crimes against the person, homicide, murder, manslaughter, crimes against the person, sexual offenses and other crimes, rape, assault and battery, false imprisonment, kidnapping, crimes against habitation, burglary, arson, trespassing, crimes against property, larceny, embezzlement, false pretense, receiving stolen property, robbery, fraud, crimes against public order, disorderly conduct, riot, crimes against the administration of justice, obstruction of justice, perjury, bribery, crimes against public morals, prostitution, obscenity. The book also covers the general part of criminal law, including the constitutional limits of criminal law, sentencing, criminal acts, criminal intent, the scope of criminal liability, and defense of criminal liability, source of criminal law. Now we have covered the various categories of criminal law. The next question to consider are these. What are the sources of criminal law? How do we find the requirements of criminal law? There are a number of sources of criminal law in the United States. English and American common law. These are English and American judge-made laws and English acts of prior implement. State criminal codes. Every state has a comprehensive written set of laws of crime and punishment. Municipal offenses, cities, towns, and counties are typically authorized to enact local criminal laws, generally of a minor nature. These laws regulate the city streets, sidewalks, and buildings that concern with traffic areas, littering, disorderly conduct, and domestic animals. Federal Criminal Code. The U.S. government has jurisdiction to enact criminal laws that are based on the federal government's constitutional powers, such as the regulation of the interstate commerce. State and federal constitutions. The U.S. Constitution defines treason, and together with state constitution establishes limits on the power of government to enact criminal law. A criminal statute, for instance, may not interfere with the freedom of expression of religion. International treaties. International treaties signed by the United States establishes crimes such as genocide, torture, and war crimes. These treaties in turn form the basis of federal criminal law punishment acts such as genocide and war crimes when Americans are involved. These cases are prosecuted in U.S. courts. Judicial decisions. Judges write decisions explaining the meaning of criminal law and determining whether criminal law meets the requirements for state and federal constitutions. Judges typically rely on precedents or the decisions of other courts in similar cases. At this point, we turn our attention to common law origins of American criminal law and to state criminal codes. The common law. The English common law is the foundation of American criminal law. The origins of the common law can be traced to the Norman conquest of England in 1066. The Norman king, William the Conqueror, was determined to provide a uniform law for all England and set rural judges throughout the country to settle disputes in accordance with the common law customs and practices of the country. The principles that composed the common law began to be written down in 1300 in an effort to record the judge-made rules that should be used to decide future cases. By 1600, a number of common law crimes had been developed, including arson, burglary, larceny, manslaughter, mayhem, robbery, rape, sodomy, and suicide. These were followed by a criminal attempt, conspiracy, blasphemy, forgery, sedition, and solicitation. On occasion, the king and parliament issued decrees that filled the gaps in the common law, resulting in the development of the crimes of false pretenses and embezzlements. The distinctive characteristics of the common law is that, for the most part, the product of the decision of the judges in actual cases. The English civil and criminal common law was transported to the new American colonies and formed the foundation of the colonial legal system that was in turn adopted by the 13 original states following the American Revolution. The English common law was also recognized by the states subsequently admitted to the Union. The only exception was Louisiana, which followed the French Napoleonic Code until 1805 when it embraced common law. State criminal codes. States in the 19th century began to adopt comprehensive written criminal codes. This movement was based on the belief that in a democracy, the people should have the opportunity to know the law. Judges in the common law occasionally punished an individual for an act that had never been subjected to prosecution. A defendant in a Pennsylvania case was convicted of making obscene phone calls despite the absence of the previous prosecution for this offense. The court explained that the common law is sufficiently broad to punish. Although there may not be exact precedent, any act which directly injures or tends to injure the public There was additional arguments that the power to make laws should reside with the elected legislative representatives of the people rather than unelected judges. As Americans began to express a sense of independence, there was also a strong reaction against being so clearly connected to the English common law tradition, which was thought to have limited relevance to the challenges facing America. As early as 1812, the U.S. Supreme Court proclaimed that federal courts were required to follow the law established by Congress and were not authorized to apply the common law. States were somewhat slower than the federal government to abandon the common law. In a main case in 1821, the accused was found guilty of dropping the dead body of a child into a river. The defendant was convicted even though there was no statute making this a crime. The court explained that good morals and decency all forbid this act. State legislatures reacted against these type of decisions and began to abandon the common law in the mid-19th century. The Indiana Revised Statute of 1852, for example, proclaimed that crimes and misdemeanors shall be defined and punishment fixed by statutes in the state and not otherwise. Some states remain common law states, meaning that the common law may be applied where the state legislature has not adopted a law in a particular area. The Florida Criminal Code states that the common law of England in relation to crimes so far as the same relates to the mode of the degree of punishment shall be with full force in this state if there is no existing provision of statute on the subject. Florida law provides that if there is no statute, an offense shall be punished by fine or imprisonment, but that fine shall not exceed $500, nor the term of imprisonment of 12 months. Missouri and Arizona also examples of common law states. These states' criminal codes, like that of Florida, contain a reception statute that provides that the states receive the common law as an unwritten part of the criminal law. California, on the other hand, is an example of code jurisdiction. The California Criminal Code provides that no act or omission is criminal or punishable except as prescribed or authorized by this code. Ohio and Utah are also code jurisdiction states. The Utah Criminal Code states that the common law crimes are abolished and no conduct is a crime unless made so by this code or ordinance. Professor LaFleur observes that courts in common law states have recognized a number of crimes that are not part of the criminal code, including conspiracy, attempt, solicitation, uttering gross obscenities in public, keeping a house of prostitution, cruelly killing a horse, public inebriation, and false imprisonment. You also should keep in mind that the common law continues to play a role in the law of code of jurisdiction states. Most state statutes are based on common law, and courts frequently consult the common law to determine the meaning and terms of the statutes. In the well-known California case of Keeler versus Superior Court, the California Supreme Court looked to the common law and determined that an 1850 state law prohibiting the killing of a human being did not cover the murder of a fetus. The California state legislature then amended the murder statute to punishment the unlawful killing of a human being or fetus. Most important, our entire approach to criminal trials reflects the common law's commitment to protecting the rights of the individual in the criminal justice system. State police power. Are there limits on the state's authority to pass criminal laws? Can a state declare that it is a crime to possess fireworks on the 4th of July? State governments possess a broad power to promote the public health, safety, and welfare of the residents of the state. This wide-ranging police power includes the duty to protect the well-being and tranquility of a community and to prohibit acts or things reasonably thought to bring evil or harm to its people. An example of the far-reaching nature of the state police power is the U.S. Supreme Court's upholding of the right of a village to prohibit more than 2 unrelated people from occupying a single home. The Supreme Court proclaimed that the police power includes the right to lay out zones where family values, youth values, the blessings of quiet seclusion, and clean air make a sanctuary for people. State legislatures informing the content of criminal code have profoundly influenced by the model penal code. The model penal code. People from other countries often ask how students consider the criminal law of the United States a country where 50 states and a federal government. The fact that there is a significant degree of agreement in the definition of crimes in state codes is due to the Model Penal Code. In 1962, the American Law Institute, a private group of lawyers, judges, and scholars, concluded after several years of study that despite our common law heritage, state criminal statutes radically varied in the definition of crimes that were difficult to understand and poorly organized. The ALI argued that the quality of justice should not depend on the state in which the individual was facing trial and issued a multi-volume set of model criminal laws. The proposed official draft of the Model Penal Code. The Model Penal Code is purely advisory and is intended to encourage all 50 states to adopt a single uniform approach to the criminal law. The statutes are accompanied by a commentary that explains how the Model Penal Code differs from existing state statutes. Roughly 37 states have adopted some of the provisions of the Model Code, although no state has adopted every single model law. The states that most closely follow the code are New Jersey, New York, Pennsylvania, and Oregon. As you read this book, you may find it interesting to compare the Model Penal Code to the common law and to the state statutes. This book primarily discusses criminal law. It is important to remember that we also have a federal system of criminal laws in the United States. Federal statutes. The United States' federal system of government. The states granted various powers to the federal government that are set forth in the U.S. Constitution. This includes the power to regulate interstate commerce, to declare war, to provide for national defense, to collect money, to collect taxes, to operate the post office, and to regulate immigration. The Congress is entitled to make all laws which shall be necessary and proper for fulfilling these responsibilities. The states retain those powers that are not specifically granted to the federal government. The 10th Amendment to the Constitution states that the power is not delegated to the states of the United States by the Constitution, nor prohibited to by its states, are reserved to the states respectively, or to the people. The Constitution specifically authorizes Congress to punish the counterfeiting of U.S. currency, piracy, and felonies committed on the high seas, and crimes against the laws of nations, as well as make rules concerning the conduct of warfare. These criminal provisions are to be enforced by a single Supreme Court and by additional courts established by Congress. The Federal Criminal Code compiles the criminal laws adopted by the U.S. Congress. This includes laws punishing acts such as tax evasion, mail-in immigration fraud, bribery, and obtaining a government contract, and the knowing manufacture of defective military equipment. The Supremacy Clause of the U.S. Constitution provides that federal law is superior to the state law within those areas that preserve the national government. This is termed the preemptive doctrine. In 2012, the Supreme Court held that the federal immigration law preempted several sections of the Arizona state statute directed at undocumented individuals. Several recent court decisions have held that the federal criminal laws have unconstitutionally encroached on areas reserved for state governments. This reflects a trend towards limiting the federal power to enact criminal laws. For instance, the U.S. government, with the Interstate Commerce Clause, has interpreted its power to regulate interstate commerce as providing the authority to criminally punish harmful acts that involve the movement of goods or individuals across state lines. An obvious example is interstate transportation of stolen automobiles. In the past few years, the Supreme Court has ruled that these federal laws are unconstitutionally based on the fact that the activities do not clearly affect interstate commerce or involve the use of interstate commerce. In 1995, the Supreme Court ruled that the United States v. Lopez that Congress violated the Constitution by adopting the Gun-Free Zone Act of 1990, which made it a crime to have a gun in a local school zone. The fact that the gun may have been transported across state lines was too indirect a connection with the interstate commerce to which is based a federal jurisdiction. In 2000, the Supreme Court also ruled unconstitutionally the U.S. government's prosecution of an individual in Indiana who was allegedly to have set fire to a private residence. The federal law made it a crime to maliciously damage or destroy by means of fire explosion any building used in interstate or foreign commerce or in any activity affecting interstate or foreign commerce. The Supreme Court ruled that there must be a direct connection between a building and interstate commerce and rejected the government's contention that a building is constructed of supplies or serviced by electricity that moved across state lines, or that the owner's insurance payments are mailed to a company located in another state. Justice Ruth Bader Ginsburg explains that this would mean that every building in the land would fall within the reach of the federal laws on arson, trespass, and burglary. In 2006, Oregon v. Gonzalez, the Supreme Court held that the U.S. Attorney General John Ashcroft lacked the authority to prevent Oregon physicians acting under the state's death with dignity law from prescribing lethal drugs to terminally ill patients who are within 6 months of dying. The sharing of powers between the federal and state government is termed dual sovereignty. An interesting aspect of dual sovereignty is that it is constitutionally permissible to prosecute a defendant for the same act under both the state and federal level, so as long as the criminal charge is slightly different. A double prosecution does not constitute double jeopardy. You might recall in 1991 that Rodney King, African American, was stopped by the Los Angeles police. King resisted and eventually was subdued, wrestled to the ground, beaten, and handcuffed by 4 officers. The officers were acquitted by an all-Caucasian jury, and they stayed in court in Simi Valley, California, leading to widespread protest and disorder in Los Angeles. The federal government responded by bringing the 4 officers to trial for violating King's civil rights to be arrested in a reasonable fashion. 2 officers were convicted and sentenced to 30 months in federal prison, and 2 were acquitted. Later in this chapter, you will be asked to decide whether the double prosecution is fair. We've seen that the state and federal government opposes the power to enact criminal laws. The federal power is restricted by the provisions of the United States Constitution that define the limits on the government's power. Constitutional limitations. The U.S. Constitution and the individual state constitutions establish limits and standards for the criminal law. The U.S. Constitution, as we shall see in Chapter 2, requires the following. A state or local law may not regulate an area that is reserved for federal government. A federal law may not encroach upon state powers. A law may infringe upon the fundamental civil and political rights of an individual only in compelling circumstances. The law must be clearly written and provide notice to citizens and to the police to the conduct that is prohibited. A law must be non-discriminatory and may not impose cruel and unusual punishment. A law may also not be retroactive and punish acts that were not crimes at the time they were committed. The ability of legislators to enact criminal laws is also limited by public opinion. The American constitutional system is a democracy. Politicians are fully aware that they must face elections that they may be removed from office in the event that they support an unpopular law. As we learned during the unsuccessful effort to ban alcohol during the Prohibition era in the 20th century, the government will experience difficulties in imposing an unpopular law on the public. Crime in the news. In 1996, California became one of the 23 states to authorize the use of marijuana for medical purposes. The other states are Alaska, Arizona, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Montana, Nevada, New Hampshire, New Jersey, New Mexico, New York, Oregon, Rhode Island, Vermont, and Washington. And the same applies in the District of Columbia. Maryland exempts medical marijuana users from jail sentences. California voters passed Proposition 215, the Compassionate Use Act of 1996, which is intended to ensure that seriously ill residents of California are able to obtain marijuana. The act provides an exemption for criminal prosecution for doctors who in turn may authorize patients and primary caregivers to possess or cultivate marijuana for medical purposes. The California legislature is directly at odds with the Federal Controlled Substance Act, which declares it a crime to manufacture, distribute, or possess marijuana. There are more than 100,000 medical marijuana users in California, and roughly 1/10 of 1% of the population uses medical marijuana in the state that collects information on medical marijuana users. Angel Reich and Diane Monson are 2 California residents who suffer from severe medical disabilities. Their doctors have found that marijuana is the only drug that is able to alleviate their pain and suffering. Brake's doctor goes so far as to claim that Angel's pain is so intense that she might die if deprived of marijuana. Monson cultivates her own marijuana, and Reich relies on two caregivers who provide her with California-grown marijuana at no cost. On August 15, 2000, agents from the Drug Enforcement Administration raided Monson's home and destroyed all 6 of her marijuana plants. The DEA agents disregarded objections from the Butte County Sheriff's Department and the local California District Attorney's Office that Monson's possession of marijuana is legal. Monson and Reich, along with several doctors and patients, refused to accept the destruction of the marijuana plants and asked the U.S. Supreme Court to rule on the constitutionality of the federal government's refusal to exempt medical marijuana users from criminal prosecution and punishment. The case was supported by California Medical Association and the Leukemia and Lymphoma Society. Reich suffered from severe chronic pain stemming from fibromyalgia, endometriosis, scoliosis, uterine fibroid tumors, rotator cuff syndrome, and inoperable brain tumor, seizures, life-threatening wasting syndrome, and constant nausea. She also experienced extreme chemical sensitivities that result in violent allergic reactions to virtually every pharmaceutical drug. Reich was confined to a wheelchair before reluctantly deciding to smoke marijuana, a decision that led her to enjoying a fairly normal life. A doctor recommended that Monson use marijuana to treat severe chronic back pain and spasms. She alleges that marijuana alleviates the pain that she describes as comparable to an uncontrollable cramp. Monson claims that other drugs have proven ineffective and resulted in nausea and create the risk of several injuries to her kidneys and liver. The U.S. Supreme Court ruled in Gonzalez v. Reich in 2005 that the federal prohibition of the possession or use of marijuana would undermine by exempting marijuana possession in California and other states from federal criminal enforcement. The Supreme Court explained that the cultivation of marijuana under California's medical marijuana law, although clearly a local activity, frustrated the federal government's effort to control the shipment of marijuana across state lines, because medical marijuana inevitably would find its way into interstate commerce, increase the nationwide supply, and drive down the price of the illegal drug. There was also a risk of completely healthy individuals in California would manage to be fraudulently certified by a doctor to be in need of medical marijuana. 3 now Supreme Court judges dissented from the majority opinion. Justice Senator Connor observed that the majority judgment stifles an express choice by some states concerning the lives and liberties of their people to regulate medical marijuana differently. Following the decision, Engelreich urged the federal government to have some compassion and to have some heart and not to use taxpayer dollars to come in and lock us up. We're using this medicine because it is saving our lives. She asked why the federal government was trying to kill her. Opponents of medical marijuana defended the Supreme Court's decision, explained that individuals should look to traditional medical treatments rather than being misled by thinking that marijuana is an effective therapy. They also argue that marijuana is a highly addictive drug that could lead individuals to experiment with even more harmful narcotics. The Obama administration initially did not enforce federal marijuana laws against individuals in medical marijuana states. In 2011, the Department of Justice announced that although individuals could grow and use small amounts of medical marijuana, that the DOJ would criminally prosecute growers of more than 100 plants and individuals involved in the commercial marketing and sale of marijuana. In 2013, the Obama administration reversed course and announced that it would not prosecute individuals in medical marijuana states unless the individuals threatened certain federal law enforcement interests. This included the distribution of marijuana to minors, providing revenue to criminal enterprises, diversion of marijuana to states where marijuana remains illegal, and the possession and use of marijuana on federal property. In 2014, Congress adopted a law prohibiting the Justice Department from using resources to prevent states from implementing their own state laws that authorize the use, distribution, possession, and cultivation of medical marijuana. Where do you stand on the medical marijuana controversy? Of course, the democratic will of the majority is subject to constitutional limitations. A classic example is the Supreme Court's ruling that popular federal state statutes prohibiting and punishing flag burning and desecration could pose an unconstitutional violation of freedom of speech. Consider the following factual scenario that is taken from the U.S. Supreme Court's description of the events surrounding the beating of Rodney King. You decide. 1.1. On the evening of March 2nd, 1981, Rodney King and two of his friends sat in King's wife's car in Altadena, California, a city in Los Angeles County, and drank malt liquor for a number of hours. Then, with King driving, they left Altadena via a major freeway. King was intoxicated. California Highway Patrol officers observed King's car traveling at speeds estimated to be in excess of 100 miles an hour. The officers followed King with red lights and sirens activated and ordered him by loudspeaker to pull over, but he continued to drive. The Highway Patrol officers called on the radio for help. Units of the Los Angeles Police Department joined in on the pursuit. One of them manned the petitioner, Lawrence Powell, and his trainee, Timothy Wind. The officers are all Caucasian. King is African American. King later explained that he fled because he feared that he would be returned to prison after being on release for 4 months. Following a year spent behind bars for robbery, King left the freeway and after a chase of about 8 miles stopped at an entrance of a recreation area. The officer ordered King and his passenger to exit the vehicle to assume felony-prone position, that is, to lie on their stomachs with legs spread and arms behind their backs. King's two friends complied. King, too, got out of the car, but he did not lie down. Petitioner Stacy Coon arrived, at once followed by Todd Brasino and Roland Solano. All were officers of Los Angeles Police Department, and as Sergeant Croon took charge, the officer again ordered King to assume the felony-prone position. King got down on his hands and knees but did not lie down. Officer Powell, Wind, Brasino, and Solano tried to force King down, but King resisted and became combative, so the officers retreated. Coon then fired taser darts designed to stun a combative suspect into King. The events that occurred next were captured on live video by a bystander. As the videotape begins, it shows that King rose from the ground and charged towards Officer Powell. Powell took a step and used his baton to strike King on the side of his head. King fell to the ground. From the 18th to 30th second on the videotape, King attempted to rise, but Powell and Wynn each struck him with the batons, preventing him from doing so. From the 35th to the 51st second, Powell administered repeated blows to King's lower extremities. One of the blows fractured King's leg. At the 55th second, Powell struck King's chest, and King rolled over and lay prone. At that point, the officer stepped back and observed King for about 10 seconds. Powell began to reach for handcuffs. At the sentencing phase, the district court found that Powell no longer perceived King to be a threat at this point. At 1 minute and 5 seconds on the videotape, Brasino and the district court's words stomped on King's upper back or neck. King's body withered in response. At 1:07, Powell Wynn again began to strike King with a series of baton blows, and Wynn kicked him in the upper thoracic and thoracic area 6 times until 1:26. At about 1:29, King put his hands behind his back and was handcuffed. Powell radioed for an ambulance. He sent 2 messages over a communication network to the other officers and said, "Oops," and "I haven't beaten anyone this bad in a long time." Coon sent a message to the police station that said, Unit just had a big-time use of force, tased and beat the suspect of CHP pursuit big time. King was taken to a hospital where he was treated for a fractured leg, multiple facial fractures, and numerous bruisings and contusions. Learning that King worked at Dodger Stadium, Powell said to King, "We played a little ball tonight, didn't we, Rodney? You know, we played a little ball. We played a little hardball tonight. We hit quite a few home runs. Yes, we played a little ball, and you lost and we won." Powell, Brasino, and Wynn were tried in California State Court on charges of assault with a deadly weapon and excessive use of force by a police officer. The officer was acquitted of all charges with the exception of one assault charge against Powell that resulted in a hung jury. The jury was comprised of 10 Caucasians, 1 Hispanic, and 1 Asian American. The verdicts touched off widespread rioting in Los Angeles. More than 40 people were killed in the riots, more than 2,000 were injured, and nearly $1 billion in property was destroyed. Los Angeles Mayor Tom Braley declared that there appears to be a dangerous trend of racially motivated incidents running through at least some segments of the police department. The President George H.W. Bush announced in May that the verdict had left him with a deep sense of personal frustration and anger, and that he was ordering the Justice Department to initiate a prosecution against the officers. On August 4th, 1992, a federal grand jury indicted the 4 officers, charging them with the violation of King's constitutional rights under color of law. Powell, Brasino, and Wynn were charged with willfully use of unreasonable force in arresting King. Coon was charged with willful permitting the other officers to use reasonable force during the arrest. After the trial, the U.S. District Court for the Central District of California, the jury convicted Coon and Powell, but acquitted Wynn and Brasino. Coon and Powell were both sentenced to 30 months in prison. This jury was composed of 9 Caucasians, 2 African Americans, and 1 Hispanic. King later won a $3.8 million verdict from the city of Los Angeles. He used some of the money to establish a rap recording business. The issue to consider is whether Officer King and Powell may be prosecuted and acquitted in California State Court and then prosecuted in federal court. This seems to violate the prohibition on double jeopardy in the Fifth Amendment of the Constitution, which states that individuals should not be twice put in jeopardy of life or limb. Double jeopardy means that an individual should not be prosecuted for more than once for the same offense. Without this protection, the government could subject people to a series of trials in an effort to obtain a conviction. It may surprise you to learn that judges have held that the dual sovereignty doctrine permits the U.S. government to prosecute an individual under federal law who has been acquitted under state law. The theory is that the state and the federal governments are completely different entities, and the state government is primarily concerned with punishing police officers and with protecting residents against physical attack, while the federal government is concerned with safeguarding the civil liberties of Americans. Each of these entities provides a check on the other and ensures fairness for citizens. The evidence introduced in the 2 prosecutions to establish police officer guilt in the King case was virtually identical. The federal prosecutor likely was brought in response to political pressure. On the other hand, the federal government historically has acted to prevent unfair verdicts, such as acquitting a member of the Ku Klux Klan charged in the killing of civil rights workers during the 1960s. Do you believe that it is fair to be subject to the Los Angeles police officers to the expense and emotional stress of 2 trials? As the Attorney General of the United States, would you have advised President George H.W. Bush to bring federal charges against the officers following their acquittal? Chapter Summary. Criminal law is the foundation of the criminal justice system. The law defines the acts that may lead to arrest, trial, and incarceration. We typically think about crime as involving violent conduct, but in fact, a broad variety of acts are defined as crimes. Criminal laws are best defined as conduct that is shown to have taken place will result in the formal and solemn pronouncement of the moral condemnation of the community. Civil law is distinguished from the criminal law by the fact that it primarily protects the interests of the individual rather than the interests of society. The purpose of criminal law is to protect conduct that causes harm or threatens harm to individuals in the public interest, to warn people of the acts that are subject to criminal punishment, and to defend criminal acts and intent, to distinguish between serious and minor offenses, to punish offenders, and to ensure that the interests of the victims and the public are represented at trial and in the punishment of offenders. In analyzing individual crimes, we will be concerned with several basic concerns that compose general parts of criminal law. A crime is composed of concurrence between criminal acts, actus reus, and criminal intent, mens rea, and the causation of a social harm. Individuals must be provided with notice of the acts that they are criminally condemned in order to have the opportunity to obey or to violate the law. Individuals will also be given the opportunity at trial to present defenses, justifications, and excuses to a criminal charge. The criminal law distinguishes between felonies and misdemeanors. A crime punishable by death or by imprisonment for more than 1 year is a felony. Other offenses are misdemeanors. Offenses are further divided into capital and other grade of felonies, pointing to gross and petty misdemeanors. A third level of offenses are violations and infractions, acts that are punishable by fines. Another approach is to classify crimes in terms of the moral turpitude. Mala and C crimes are considered inherently evil, and mala prohibita crimes are not inherently evil, and are only considered wrong because they are prohibited by statute. Our textbook categorizes crime in accordance with the subject matter of the offense, the scheme that is followed in most state criminal codes. This includes crimes against the state, crimes against the person, crimes against habitation, crimes against property, crimes against public order, and crimes against the state. There are a number of sources of American criminal law. These include common law, state and federal criminal codes, the U.S. and state constitutions, international treaties, and judicial decisions. The English Common